3 weeks before Christmas, I overheard my son and his wife planning to have me declared mentally incompetent, seize control of my finances, and move me into a memory care facility before the new year. They'd been living in my home for 14 months without paying a single dollar in rent, eating my food, using my utilities, and calling it family. On Christmas morning, my son called and asked where I was. I told him to check the kitchen counter. What he found there changed everything he thought he knew about his father. I want to tell you exactly how it happened, because I almost didn't survive it, and because somewhere out there, someone else might be living the same story right now. My wife passed in February, 39 years of marriage, and then one morning she was simply gone. The doctors called it a cardiac event. I called it the end of the world as I understood it. We'd built everything together, the house in Clearwater, the retirement accounts, the small rental property we'd bought in 2009 when prices were low. She handled the garden, I handled the books, we were a system that worked, and then suddenly, I was half a system, rattling around in 4 bedrooms that still smelled like her perfume. My son called 3 days after the funeral. He said he and his wife were worried about me being alone. Said it didn't make sense for me to rattle around in that big house by myself. He'd been laid off 6 months earlier. Something about restructuring at the tech firm where he worked, and his wife's salon business had never quite recovered after the pandemic. They had credit card debt I didn't know the full extent of. He asked if they could come stay for a while, just to help me through the grief, just to make sure I was okay. I said yes because he was my son and I loved him, and because the house did feel enormous at night. That was 14 months before Christmas. I was 67 years old, a retired CPA with 40 years of reading financial statements, tax returns, and the kind of documents most people never think about until they need them. My mind was as sharp as it had ever been. I read 2 books a month, did the crossword every morning, managed my own investment portfolio with the same discipline I'd applied to client accounts for 4 decades. I was not confused. I was not declining. I was grieving, which is an entirely different thing. And the 2 of them had apparently decided to use that grief as a doorway. The day I found out was a Wednesday in early December. Cold front had pushed through overnight, unusual for Florida, and I'd come home from the pharmacy earlier than expected. My blood pressure prescription had been called in early, routine thing, and I was back by 2 in the afternoon instead of 4. I came in through the garage, the way I always did, and set my keys on the hook by the door. I heard my daughter-in-law's voice from the living room, sharp and certain, the way she talked when she thought no one important was listening. The financial advisor confirmed it today, she was saying. With durable power of attorney, he gains full control the moment the doctor signs off. We don't need a court order if we have the right documentation in place first. I stopped moving, stood completely still in the laundry room doorway. My son's voice, lower. And the doctor will sign off? Dr. Harmon said the assessment shows clear cognitive decline. Memory issues, difficulty managing finances, increased confusion. He said it's consistent with early-stage Alzheimer's. Once he submits the formal report, we file for voluntary POA. Dad signs it thinking it's just a precaution, and then we're in control of everything. The Vanguard accounts, the IRA, the rental, all of it. And we sell this house. It's worth what, $850? We pay off the debt, put him in Harbor Pines, and we start over. Harbor Pines was a memory care facility on the north end of Clearwater. I'd driven past it 100 times. Nice landscaping, locked doors. He's not going to like it, my son said. He doesn't have to like it. That's the point. Once the paperwork is in place, what he likes doesn't matter. I stood in that laundry room for what felt like a very long time. Then I walked back to the garage, got in my car, backed out of the driveway, and sat in the parking lot of a Publix 3 blocks away. The man who had trusted his son with a key to his home. The man who had made Sunday dinners every week for 14 months. The man they planned to lock away before Christmas. I sat there until my hands stopped shaking. Then I pulled out my phone and called the only person I completely trusted. My old colleague Frank had retired 4 years before me after 32 years as an estate planning attorney in Tampa. We played golf badly together every other Thursday and had lunch at the same diner for 15 years. I told him what I'd heard. He didn't say anything for a long moment. "Don't go back in that house looking upset," he said. "Don't change anything. Go home, act normal, and come to my office tomorrow morning. 8 o'clock, Frank, 8 o'clock, and bring every financial document you can carry." When I walked back into my own house at 4:30, carrying a pharmacy bag and wearing the face of a man who'd had an ordinary afternoon, my daughter-in-law was making tea in my kitchen. She smiled at me, asked how the pharmacy visit was. I told her it was fine, just a refill, nothing interesting. I sat at my kitchen table and read the newspaper. She stood 12 feet away and smiled at me like she hadn't just described putting me in a locked facility before the new year. That was the hardest 20 minutes of my adult life. At Frank's office the next morning, I spread the documents across his conference table. Deeds, account statements, the retirement portfolio summary, insurance policies. Frank put on his reading glasses and went through everything methodically, the way he always worked, slow and certain. "This Dr. Harmon," he said. "Have you ever been his patient?" "Never met him." "Then whatever assessment he wrote it without examining you. That's not a medical opinion. That's a document created for the purpose of fraud." He looked up. "Here's what they're counting on. They're counting on you not knowing your rights, and on the legal process being slow enough that by the time you understood what was happening, the paperwork would already be filed. Standard elder financial exploitation play." "What's my move?" Frank set down his glasses. "Defensive first. We create an irrevocable trust today. Everything goes in the investment accounts, the IRA rollover, the rental property. You remain the trustee, you retain all income, but the assets are legally protected from any external control claim. Even with a valid POA, they can't touch what's inside an irrevocable trust without your consent. And the house? The house is different. It's not in the trust. But you can sell it." He paused. "Can you sell it before they file? How long do I have?" "If they're talking about before Christmas, and today is December 5th, you have roughly 3 weeks. If they file for emergency guardianship through the courts, which requires a physician's report they apparently already have, a judge could issue a temporary order within 72 hours. You need to move faster than that. 3 weeks, 21 days to dismantle everything they thought they were inheriting." "Let's start the trust paperwork today," I said. Frank's paralegal had the documents drafted by noon. I signed everything in Frank's conference room while his assistant notarized each page. Investment accounts went into the Harold Mitchell Family Trust. The rental property transferred. The IRA rollover restructured. All of it legally sealed, behind a wall they couldn't touch. By 2 in the afternoon, I had a new checking account at a credit union 3 towns over, no connection to any account my son knew existed. Frank handed me a business card. "This is Carol Briggs, best real estate attorney in Pinellas County, and she moves fast when she needs to. Tell her I sent you, tell her the timeline, and do it today." I called Carol from the parking lot of Frank's building. She had an opening that afternoon. Her office was in a converted Victorian on a quiet street in St. Petersburg. She was 60 herself, I guessed, efficient in the way of someone who'd been solving problems for a long time. She reviewed the deed while I sat across from her. "Sole owner. No encumbrances. No liens," she said. "You can sell. The question is whether you can close before December 23rd, which is your hard deadline based on what you've told me. Can it be done? I have a buyer I work with regularly. Investor. Cash purchases. Closes in 10 days if the title is clean. He'll pay market minus 8% for the speed. You're at 850 on Zillow. He'll offer 780, maybe 785. Call him." She looked at me over her glasses for a moment, the same way Frank had. The look that meant she understood this was more than a real estate transaction. "I'll call him now." By 6 that evening, I had a verbal offer at 782. Cash. Close date December 20th. I drove home, parked in my driveway, sat for a few minutes looking at the house my wife and I had bought in 1998. The big oak in the front yard that she'd planted from a sapling. The porch where we'd sat every Sunday with coffee. I let myself feel that for exactly 2 minutes. Then I went inside. My son was in the living room watching television. Asked how my afternoon was. I told him I'd had lunch with Frank. Did a little shopping. Felt tired. He nodded, went back to the screen. His wife came in from the kitchen, asked if I wanted dinner. I said I'd just make something simple. She said okay and sat next to my son on the couch. The two of them together on my furniture in my house, already planning how to divide what they thought was theirs. Christmas is coming up, I said from the doorway. I was thinking we should do something special this year. My son looked over. Yeah? Like what? I don't know yet. Something memorable. He smiled. Sounds good, Dad. I went to my bedroom and closed the door. Lay on top of the covers in the dark. Made a list in my head of everything that still needed to happen and the order in which to do it. I had discovered something about grief in the 10 months since my wife passed. It does not make you soft. Sometimes it removes everything unnecessary and leaves only what is essential. What was essential now was protecting what she and I had built together from people who thought love was a transaction you could manipulate. The next morning, I called my own doctor and scheduled a full cognitive assessment. I wasn't worried about the results. I wanted the documentation. If Dr. Harmon had signed a report claiming I was declining, I needed dated counter-evidence from a physician who had actually examined me. My doctor, who had been my physician for 16 years, agreed to a 2-hour comprehensive evaluation. I walked out 4 days later with a written assessment confirming excellent cognitive function, memory performance in the top quartile for my age group, and no indicators of any dementia-related condition. I asked for 3 certified copies. Meanwhile, I kept the routine. Made coffee in the mornings, read the paper, watched the evening news, asked my son about his job search, asked my daughter-in-law how the holiday bookings were going at the salon. I was the man they thought they knew. The grieving father who didn't notice things, who needed to be managed, who could be guided gently towards signing documents that would end his autonomy. I was also recording. Florida is a 2-party consent state for in-person conversations, but 1-party consent for phone calls I was part of. For conversations in my own home, I reviewed the statute carefully, 3 times. The way I reviewed tax code. I placed a small digital recorder in the kitchen, where most of their conversations happened. I wasn't certain it was legally admissible. Frank told me it created context, and context mattered in court. I placed another in the living room, moved them every 2 days, so the positioning felt natural. On December 9th, my daughter-in-law took a phone call in the kitchen while I was ostensibly in my bedroom. Her voice carried clearly. She was talking to someone about timeline, about the assessment being submitted to the county court, about before the holidays being the goal. I heard her say, "He has no idea," with the particular confidence of someone who has never been wrong before. I sat on my bed, taking notes in a yellow legal pad I kept locked in my briefcase. On December 12th, I signed the purchase agreement with Carol Briggs's investor. $782,000, cash, closing on the 20th. I had the wire transfer directed to the new credit union account. Not a single comma of it connected to anything my son could find through the accounts he knew about. That evening, I created what Frank called the Christmas envelope. I typed a letter on my old desktop computer. Clear, calm, factual. I attached a copy of the executed purchase agreement, dated, notarized, the closing date visible. I attached a copy of the trust documents, showing all accounts had been transferred 30 days prior. I attached my cognitive assessment from my physician, with his letterhead and signature. I printed everything, placed it in a manila envelope, and wrote on the front in black marker, "Open this before you do anything else." I put it on the kitchen counter where they would find it on Christmas morning, after I was gone. My son knocked on my bedroom door that night, asked if I was feeling okay, said I'd seemed quiet lately. I told him I was just thinking about the holidays. He sat on the edge of the chair by my desk and looked at me in a way that might have been concern or might have been assessment. "Dad, I want to talk to you about something," he said. "Sure." He leaned forward. "His wife and I have been worried about you since Mom passed. We just want to make sure you're protected, that everything is taken care of properly." "I appreciate that," I said. "We were thinking maybe it would make sense to talk to someone about, planning, estate stuff, just to make sure there's a plan in place if something happens to you. I've been taking care of my own estate for 40 years, I said, keeping my voice gentle. "But I'll think about it." He nodded, seemed satisfied, left the room. I sat still for a long time after. 3 days before Christmas, Carol called. Everything was on schedule. The buyer's funds were already in escrow. Close date confirmed as the 20th. December 20th, I met Carol at the title company at 9 in the morning. I signed the final documents for 45 minutes. Shook hands with Carol, thanked her. Watched the wire transfer confirmation appear on my phone. $782,000, less fees, landing in an account my son had no idea existed. That evening, I came home to my own house for the last time, knowing it was the last time. I had packed 2 weeks earlier, gradually, carrying bags to my car when they were both out. Clothes, documents, my wife's photographs, the wooden box she kept her mother's jewelry in, her gardening journal from 2019, the last one she'd written in, the small things that meant everything, nothing that required explanation. I left the furniture, the television, the kitchen equipment, let them have the objects. I was taking the life. My son grilled chicken that evening. His wife made a salad. We ate together at the kitchen table for what turned out to be the last time. They talked about New Year's plans, about a friend's party, about someone from his old job who'd reached out. I listened, ate my dinner, helped clear the plates, said goodnight at 9:30, told them I was tired. In my bedroom, I set my alarm for 5:30 and lay in the dark looking at the ceiling. 39 years of a marriage that had made me the person I was. A son I had coached in Little League and driven to college, and helped move 4 times across 3 states. A house that was no longer mine, sold to a stranger for cash, already someone else's on paper. I did not sleep much. At 5:40 on December 21st, I loaded the last of my things into my car and left before they woke. I didn't look in the rearview mirror. I'd learned years ago that looking backward was how you drove into a ditch. I had booked a suite at a Marriott in Tampa, paid in advance, 3 nights. After that, I was heading to Asheville, North Carolina, where I'd already put a deposit on a rental property. 6 months, a 2-bedroom house near the river with a small porch and mountain views. I had a call scheduled with a buyer's agent for the first week of January. I was going to find something permanent, something mine, somewhere the air was cold and no one knew my family. I checked into the hotel at 7 in the morning. The young woman at the front desk said I was early, the room wasn't ready yet, but she'd have it turned over by 8. I sat in the lobby with a coffee and felt something I hadn't felt in months. Quiet. Not the lonely quiet of an empty house, but the earned quiet of a man who had handled his own situation. At 8:15, I settled into the room, set my laptop on the desk, called Frank. "The envelope is on the counter," I said. "They'll find it when they come down for coffee." "And the closing?" "Completed yesterday. Funds received." Frank made a sound that, for him, passed as satisfaction. "Robert, they're going to come at you hard when they understand what happened. Let them. They may try to claim you were incompetent when you signed the trust documents and the sale agreement. That's the standard play when the asset grab fails. You need to be very clean. I have the physician's assessment dated November 30th. The trust was signed December 6th. The sale agreement December 12th. The documentation will show a man in full possession of his faculties, making deliberate, sequential, legal decisions over a 3-week period." "Good." He paused. "Merry Christmas, Harold." That was the first time he'd used my name in the conversation. Christmas Eve came and went quietly. I ordered room service. Watched a movie I'd been meaning to see for 2 years. Slept 8 hours. On Christmas morning, I sat by the window with coffee and watched Tampa traffic below, the particular sparse movement of a city on a holiday, and waited. At 9:47, my phone rang. My son's name on the screen. I let it ring 5 times, then answered. "Dad." His voice was strange, compressed. The voice of someone trying to hold a large and unmanageable thing still. "Dad, where are you? We came down this morning and you're not here. There's an envelope on the counter. Did you read it?" Silence. Then, "What is this? What is this document?" "It's a purchase agreement. The house closed on the 20th. It's not my house anymore, which means it's not yours either." More silence. I heard his wife's voice in the background, the quick murmur of someone asking a question. "I don't understand," he said. You sold the house. Yes, without telling us. It was my house. I didn't need to tell you. Dad, his voice cracked. Whether from genuine emotion or the realization that the strategy had collapsed, I couldn't tell and had decided it didn't matter. Dad, we've been worried about you. Dr. Harmon said. Dr. Harmon, I said, never examined me. Whatever document he signed based on information you provided him, not based on any actual assessment. I have documentation from my own physician, Dr. Ellison, who has been treating me for 16 years, confirming full cognitive function. It's dated 2 weeks before I sold the house. Another silence, longer this time. Where are you? He asked. His tone had shifted. The concern, whether real or performed, was gone. What remained was something more direct, somewhere comfortable. We need to talk about this in person. You can't there are things we need to discuss. The accounts, the properties. The accounts are in a trust I established on December 6th. They were transferred before any document of Dr. Harmon's was filed with anyone. The rental property is in the same trust. The proceeds from the house are in a separate account in my name only. There's nothing to discuss. He said nothing for a long time. I recorded the conversation you had in the kitchen on December 5th, I said. Your wife's voice is very clear. I have it saved in multiple locations. When he spoke again, his voice was different, smaller. Dad, I'm going to let you go now. You have a lot to figure out. I ended the call, set the phone on the desk, looked out at Tampa Bay in the distance, at the particular flat silver of Gulf water in December. Then I blocked both of their numbers, screenshotted the call log for Frank's records, and called Frank to tell him they knew. An hour later, my son called from an unknown number. I let it go to voicemail. Listened to the message once. He said they wanted to work things out. Said his wife was upset. Said they had nowhere to go. The lease on their old apartment was up. They'd given up that apartment when they moved in with me. Said surely I could understand the position they were in. I understood the position they were in very well. I had created it, legally and deliberately, over 3 weeks while they made dinner in my kitchen and assumed I was declining. I sent the voicemail recording to Frank. Then I blocked that number too. The legal response came faster than I expected. Frank called on December 28th to tell me my son had retained an attorney and filed a petition claiming the house sale was the product of financial exploitation. The theory was that an outside party had taken advantage of a vulnerable elder. The outside party, apparently, was me exploiting myself. It's a thin argument, Frank said, but judges can respond to it in the short term while they gather information. We need to get ahead of this. We filed our response the first week of January. 3 certified copies of my cognitive assessment, the trust documents with execution dates, the sale agreement with Carol's firm, recorded excerpts from December 5th, a sworn affidavit from Frank attesting to the sequence of events and my state of mind during each meeting, a separate affidavit from Carol Briggs, a letter from my physician. My son's attorney filed a motion requesting the court order an independent psychiatric evaluation. The judge, a retired Superior Court judge named Patricia Holden, sitting in Pinellas County, granted the evaluation. I drove back to Clearwater from Asheville in January, appeared for the evaluation in a beige office building off US 19. The evaluating psychologist, Dr. Simmons, was in her 50s and conducted the session without any visible opinion about the circumstances that had brought me there. 6 hours of conversation, memory testing, cognitive assessments, written evaluations. At one point she asked me to describe the decision to sell my house and establish the trust. I discovered on December 5th that my son and his wife had engaged a physician to produce a false cognitive assessment in order to secure power of attorney over my finances and facilitate my placement in a memory care facility. I said, I consulted an estate attorney the following day. Over the subsequent 2 weeks, I transferred my assets into an irrevocable trust, retained separate legal counsel to execute the sale of the property, and documented each step of the process. I left the home on December 21st, leaving documentation of the completed transactions on the kitchen counter for them to find Christmas morning. That's a detailed sequence, she said. I'm a retired CPA. I've been executing detailed financial sequences for 40 years. She made a note, did not say anything that indicated a conclusion. Dr. Simmons's report was filed with the court on January 22nd. Frank read it to me over the phone. She had found no evidence of cognitive decline, no indicators of dementia or impairment, no signs of confusion or vulnerability. Her conclusion was that the subject demonstrated complete decision-making capacity and that the actions taken were consistent with a rational response to a perceived and apparently legitimate threat. Apparently legitimate, I said. That's her being conservative, Frank said. What she means is it was a completely legitimate threat and you handled it appropriately. Judge Holden will dismiss. The hearing was brief. Judge Holden had read everything. She denied my son's petition in less than 10 minutes, noted that the petitioner's own evidence was undermined by the documented timeline showing clear, sequential, legally sound decision-making, noted that the physician whose assessment the original plan rested upon had not, in fact, examined the subject. She didn't say the word fraud from the bench. Her eyes said it. In the hallway afterward, Frank touched my arm. It's over on the legal side. They have no remaining avenue. I nodded. Looked through the courthouse glass doors at the January parking lot. They'll be served with the counter filing next week, Frank said. 14 months of rent at market rate comes to just over $26,000. Damages for the fraudulent physician engagement and the emotional distress of the legal proceedings were asking $52,000. Total exposure, $78,000. They don't have $78,000. No, they have approximately $12,000 in a joint checking account, a car each, and furniture. One of the attorneys floated a settlement conversation, $10,000, and a formal acknowledgement of liability. I'm not interested in the money, I said. Frank raised an eyebrow. I'm interested in the acknowledgement of liability, I said. Make it public record. I want anyone who looks up their names to find a civil judgment for elder financial exploitation. That's achievable. The formal judgment was entered in February. $22,000, which represented what they could realistically pay given their circumstances, plus a formal civil finding of fraudulent conduct. The judgment became public record in Pinellas County. Searchable, permanent. My daughter-in-law had lost her lease on the salon space in January. The landlord had found the court filings, declined to renew. She was working at another salon now, hourly, no ownership. My son had applied for several positions and been turned down at the final stage twice. I had nothing to do with that. Public record search is simply a thing that employers do. I was in Asheville when Frank sent me the final update. I was sitting on the porch of the rental house with coffee and the newspaper, watching fog lift off the mountains in the late morning, a particular slow dissolving that I'd come to look forward to every day. I donated the $22,000 settlement to the National Center on Elder Abuse. Kept no record of it except a receipt. Sent Frank a copy with a note that said thank you. In March, I made an offer on a small house in West Asheville. 1,700 square feet, 2 bedrooms, 1/3 of an acre, with a creek running along the eastern edge. The former owner had built raised garden beds along the south side. I accepted those as part of the purchase, even though I'd never gardened in my life. I figured I had time to learn. A letter arrived in late February, forwarded through Frank's office. My son's handwriting. I recognized it from birthday cards over the years, the particular way he made capital letters slightly larger than necessary. I sat with the envelope for a while before opening it. He wrote that he was sorry. Wrote that his wife had pushed harder than he had convinced him that I needed the intervention, that the plan had been framed to him as concern rather than control. He wrote that he understood if I didn't believe that. Wrote that losing access to me had been the worst part, worse than the legal outcome, and that he thought about calling me every day. He did not ask for money. He did not ask for anything concrete. He asked only whether there was any possibility of a conversation someday. I read it twice. Then I put it in the fireplace in my rental house and watched it go. My wife would have told me I was being too hard. She would have put her hand on my arm and said something about the relationship being more important than the outcome, about forgiveness being a thing you do for yourself. She would have been right in the way she was right about most things. but my wife wasn't here. And the people who had looked at me across my own dinner table and described the logistics of putting me away had not been thinking about her, or about me, or about the 39 years of work it had taken to build what they tried to take. They had been thinking about debt relief. I closed the fireplace screen and went to make dinner. Spring came slowly to the mountains. The garden beds along the south side of my new house had been planted by the previous owner with perennials, daylilies, black-eyed Susans, some variety of salvia I couldn't identify. I learned their names from a book I bought at the local garden center. I learned which ones needed cutting back and which needed to be left alone. I made mistakes, overcorrected, made different mistakes. The garden kept growing anyway. I played golf with a group of retired men from the neighborhood on Tuesday mornings, ate at a good Mexican restaurant on Friday evenings, joined the local library, and worked my way through a reading list I'd been putting off for years. In June, a text arrived from an unknown number. My son, different phone. He said he was in Asheville for a friend's wedding and wondered if I wanted to have coffee. Said he understood completely if I didn't. I stared at the text for a long time. Then I typed, "I'm not ready for that." I sent it, blocked the number, sat in my garden with the evening light cutting through the oak tree overhead, long summer shadows across the raised beds. I was not ready. That was the honest answer. Not an excuse, and not a door permanently closed, just the simple statement of a man who had learned to be honest about what he was and wasn't prepared to carry. My wife had taught me that, in her way. Don't say yes when you mean no. Don't say fine when you mean hurt. Don't say later when you mean I don't know. I don't know whether there will ever be a conversation. I know that the life I have now is mine in a way the previous one had stopped being. I know that the creek behind my house runs different in rain and in drought, and that the sound of it is different at noon than at midnight, and that learning this took longer than I expected, but was worth the time. I know that grief is not a thing that ends. It's a thing that changes, and that building a new life is not betrayal of the old one, but simply the next act of the same story. I know that at 67 years old, in a mountain town where no one knew my history, I planted black-eyed Susans in soil I owned and watched them grow all summer and felt, for the first time in a very long time, that the ground beneath me was solid. And I know that an old man who looks confused can still read the fine print. They counted on me not knowing my rights. They counted on grief making me soft and slow. They counted on the paperwork being too complicated and the timeline being too short and the father being too sentimental to respond decisively. They were wrong on every count, because what they mistook for sentimentality was simply love, and love is not the same as weakness. And I had spent 40 years making sure nothing caught me unprepared. I left them the furniture and took the life. That seems right to me still. If you have a parent who is aging and alone, and you are genuinely worried about them, call them. Have the honest conversation. Ask them what they need. Offer to help in ways that serve them, not in ways that position you near their assets. That is what a family does. That is the version of this story where no one ends up in a courtroom and no one ends up donating a legal judgment to a charity that exists because this happens too often. If you are that parent, let me tell you something I had to learn the hard way. Your age is not your vulnerability. Your loneliness is not your weakness. Your assets belong to you, and the law exists to protect them. And there are people who know how to use that law, and you are allowed to be one of them. My wife's gardening journal sits on my nightstand. The last entry is from October 2022, 5 months before she died. She wrote about the daylilies she wanted to plant in the spring. She wrote that she'd finally found a variety that would hold color through July. She wrote that she thought the south side of the yard got just enough light. She was right. She almost always was. I planted them in May. They bloomed in June. They're still going. If you found this story meaningful, please subscribe to the channel and leave a comment telling me where you're watching from. And if this story sounded familiar, if you recognize something in it, please share it with someone who might need to hear it. To hear the next story, click on the box to your left. Thank you for being here.